Hello, Law Geeks. I hope you are all doing great. This video is being presented by Credence Law Learning for the educational purpose. We are going to discuss about the practical oriented questions from the company law. The first question that I've taken up from the past paper, the first question is, there was M who was a wealthy man having a huge dividend, and he formed four private companies so that he can evade the tax. Now the question is, can the court lift the corporate veil? The answer for this question is similar to the case of Sir Dinshaw Manekji Petit. So for this kind of questions, first you're gonna write facts of the case, then you would continue speaking of its issues raised. So what is the issue here? Can a court order the lifting up of the veil of those four companies? Now, the concept which is related to the question given, that is lifting up of the corporate veil. Lifting up of the corporate veil is where we have the concept of corporate personality. Since company is an artificial person, company cannot think, company cannot sense. It is the people who are taking the actions behind the company. In order to know who are the persons who are actually behind the acts of the company, the corporate will be lifted. So here, this given case is similar to the case of Sir Dinshaw Manekji Petit. First, you're going to write facts of the case. Then you would talk about issues raised and the concept, similar concept, you are going to explain it in half page. Half page, you are going to explain it. And then write a similar case. And finally, when you give judgment and give the reasoning behind judgment. Reasoning for allowing to lift the corporate veil is in case if a company is acting to evade the tax, to avoid the tax, at that point of time, that is one ground for the lifting up of the veil of the company. This is the first case, Sir Dinshaw Manekji Petit. The second case here we have is there was a company which was incorporated where the person was acting as a managing director and he was also appointed himself as an employee. While he was working, he died. Later, the widow asked for the compensation. Now, the question is, will she succeed? The facts of the case is given in the case question itself. Speaking of the concept here, the given question is similar to the case of Lee versus Lee Air Farming Company. Lee versus Lee Air Farming Company. Here again, the concept of separate legal entity. The concept of separate legal entity was emphasized by the Court of Law. The Court of Law said company is different, its members are different. Though he was a managing director and he was also acting as the employee himself in the company, the corporate veil will be lifted, and by virtue of the corporate veil, the widow was entitled to get 2,400 as a compensation. 2,400 bonds as a compensation. So this is the Lee versus Lee case. Then we have the third case here. PQ and R are the members of the company and they were holding the shares of the majority of the shares they were holding. And then they transferred all the shares to other three people. Now the question is it a perpetual succession? Will the concept of perpetual succession continues? Yes. There's a concept of perpetual succession. Perpetual succession is a characteristic feature of a company wherein it says company exists, company takes birth by the process of incorporation and ends only by the process of winding up of the company. It's winding up process, the company comes to an end. Here it says company exists, company continues to exist irrespective of the change that it takes place within its composition of the members. That is why MC Gover also once, Justice MC Gover once emphasized, people may come, people may go, but the company will continue to exist. It's like a river theme, it continues to exist. By virtue of perpetual succession, the concept of perpetual succession, yes, the company will continue to exist. Then we have it's a quick information about the classes available. If you're looking for notes, classes, and if you have any doubts, you can contact to the number given. Then we have the fourth case here. During the war, all the members of a private company, while they were attending the general meeting, they were all killed in the bomb. This given question is similar to the case of Meat Supplies Guildford case, limited case. Here in this case, what happened during the war, where all the members of the company were attending the general meeting, They were all killed by the bomb. The question was, since all the directors died, will the company continues to exist? The Supreme Court, the court at that point of time, the court held that yes, company exists irrespective of the change that it takes place within its composition. By virtue of perpetual succession, yes, the company would continue to exist. Then comes prospectus. A company, if the company issues prospectus as an advertisement in the newspaper, will it consider to be the prospectus? No, a prospectus cannot be in the form of an advertisement placed in the newspaper and magazine. It cannot be. Prospectus in general, it's a kind of a document which is issued where it is asking for the public to invest in the shares of the company. It's like a prospectus. It talks about the company. Then we have the next case, the kind of a question it is. The question is, upon the instruction of certain people, the few persons, they incurred the fees and they indulged all the incidental expenses for the registration of the company. The question is, uh, once the company is incorporated, will they be liable? Will they be, will they have the right to get the expenses that they have paid before the company was incorporated? Yes, it is one right of the promoter to receive all the preliminary expenses that you have incurred um, before the registration of the company by the board of directors. Yes, the person is entitled to receive the preliminary expenses. It's a right of a promoter. So promoter, who is a promoter? Promoter is the one who takes up all the preliminary functions of the company. Who would first, he is the one who is going to take the first step of the company. Once the company is incorporated, he have all the rights to get the compensation, the expenses, whatever he have spent by the board of directors. And we have a case due to some disasters. One company was suspended for a year. Now shareholders, they submitted, they wanted it to stop. Here, this given question is where it talks about section 433. 433 subsection C, it says the circumstances in which the company is to be owned up compulsorily. Compulsory in the sense it is by a tribunal. When it is compulsory winding up, if the company does not commence a business within a year, within 12 months of its incorporation, then the company is to stop. By virtue of 433, here the company which did not started business within 1 year of its incorporation, then it will be asked to compulsorily close by the tribunal. It's by the court. It's a compulsory. These are all the certain repeated cases which you can see in the past papers. And give importance to all the important questions from the company law. We have a corporate personality, with lifting up of the veil, promoter, director, meeting, and winding up process, shares, debentures, dividends, pre-incorporated contracts, and the concept of corporate social responsibility. You just 1 day left for your exam. I wish all the best for your upcoming exams. And if you have any queries, you can contact us. And the last question that I'm going to discuss is, there was a person who was holding an office in the as a director in almost 15 companies. Now he want to get a position of a director in a 16th company. Now the question is, will he be able to get the directorship? Yes. Why? Because it is by virtue of section 165 subsection 1 of the Companies Act of 2013, wherein it says that a person can hold the office of directors up to 20, maximum 20. He can be a director to 20 companies. This is all about the important questions. I wish you all the best for your upcoming exams. If you have any queries, you can contact the number given. All the best.